Hello, Anthony.
Hello, Claudine.
We are here today to talk about an FBAR litigation win. We like to stay on top of these because there's not a ton of FBAR litigations happening.
That's right.
Okay, so this is Jeffrey P. Pomerantz. He's a dual U.S.-Canadian citizen. He had 2 overseas accounts, one in Canada at CIBC in his own name.
That's right.
The other was in Switzerland under a shell company's name. He did not file FBARs on either account from 2007 to 2009. So this ended up going to court.
Yeah, it did. It did go to court. So this is what happened in the case. The IRS is in charge of assessing the Title 31 FBAR penalties, even though the IRS is a Title 26 agency. The reason being is because the Title 31 FBAR form, it's so low value for intelligence, and there's so much of it. The only agency that can actually handle it isn't the agency who publishes the form. That's the Financial Crimes Enforcement Network. It's their form, yet they don't want to touch it because it's a waste of their time. So they they ship it off to the IRS to handle, and the IRS has developed its own penalty procedures for assessing FBAR penalties, and in this case, willful FBAR penalties. And when I've read the complaint, the court opinion says there was 2 overseas accounts. It looks like there's 3. Can't quite tell. Not that it matters much. The result is still the same. A fantastic win for Mr. Pomerantz, who did represent himself.
That's awesome.
That's pretty awesome. I'm pretty sure he had some help because he was trying to also move the case to Washington, D.C., where he had an attorney who was willing to help him. So I'm wondering if that attorney helped him at all on this brief. Who would know?
Perhaps.
Maybe just some legal research. He was not representing him in court, of course. So, I mean, it just went incredibly well. He did lose on the motion to change the venue where his attorney could represent him, but it wasn't so important because the victory was when something like this. So the IRS assessed these willful penalties against them, and it says, oh yeah, so you hid these assets because you didn't file the FBAR. Boom, willful FBAR penalties. That's the standard the IRS constantly wants. Say, well, you just didn't even file this, therefore we should go for willful. The courts, here we have a court saying, whoa, back off. You kind of need a little bit more than just not filing an FBAR. If you were going for a non-willful penalty, okay, you got him. He didn't file the FBAR. And now, because you're going for the willful penalties, you have the burden of proof. You have to allege additional information that would lead someone to say, okay, yes, they could have. And again, this was a motion to dismiss the complaint. This wasn't even a summary judgment or a trial. This is just gone, motion to dismiss. Your complaint was so bad, you're out of here.
Wow.
And that's what happened here because this is what they did. They just said, okay, so the CIBC account, he failed to file, period. And the court's like, and? Well, you know, that was willful. Like, well, no, you're just saying it's willful, but you're not alleging any facts.
No proof.
And the court says, well, unlike your other allegation of the Swiss account, you allege that he's using a shell account. Okay, you're using a shell account. Okay, I guess that's a fact that I could infer willfulness. So the result could have been he would have won on the CIBC account, lose or not prevail right now on the Swiss account. However, the judge says, well, I'd love to do that, but I can't quite do that. And the reason why is because you guys combined the FBAR penalties together, so I have no idea which is which. And I looked at the complaint, and it's like, oh yeah, you did. You didn't bother.
They don't even know how to do their own.
They didn't. Well, I know now they do. So yeah, this is hey guys, this isn't looking so good for us. So he kicked that whole thing out. It's like, I don't know what's what. You're just saying all FBAR penalties. Well, maybe this is all for this and nothing's for that. So here it is. Goodbye. You lose, government. Now, the government can refile. It's possible they do. I don't know. I mean, I imagine they're stewing and absolutely angry at the judge for this travesty. And where I don't share the same anger, I'm very happy with this result. I would say this though, that the result very pro-taxpayer. We're seeing the same thing though. There is a controlling FBAR case. That controlling case is Ratzlaff versus United States. It is a Supreme Court case. It's a Supreme Court case that sets the standard for assessing willful Title 31 penalties.
Okay.
The court mentions it, but he doesn't go into detail as like, this is the one. It just mentions it along with other cases. And so if this does go back, I think some more focus on Ratzlaff to making sure the government is reaching that very high standard, because I think they're going to lose on, I mean, at this point, we have a ruling on CIBC. No, you need other facts besides not filing an FBAR.
Right.
It was in his own name. What did he do to conceal this? And that's really the thing. He didn't do an action to conceal it, but he took no active actions to conceal it.
Yeah.
Someone actively getting a shell company, I guess that's a bad fact, but we also know around the world, that's the way business is done. You don't get a bank account in your own name around the world just for liability purposes.
Right.
You don't do it. So
LLCs are normal here,
right.
And it's similar to an LLC overseas.
A lot of things are similar, or this is just the way it's done. You buy an off-the-shelf thing. Oh, here, just get this one. Here, sign it. The banker just gives it to you. Has nothing to do with tax evasion. It's just the way it's done.
Yep.
So I wouldn't even say that shell companies on its own really mean all that much when you look at the facts. When you actually look at the facts, it's always the boogeyman we're trying to create. It's like, well, why did you get that shell company? That was what they told me to do. I don't know.
Yeah.
I don't know who. It was a company that was old. I don't even know where it was from. I don't know what that name means. It's always some weird name. Like, I didn't name it. It's just that.
Right.
So I would say that number one, if it's not in if an account is, this is really what's important of the Pomerantz decision.
Okay.
If an account is in your name, the IRS is going to have a real tough time proving you were willful.
Yes. And I like that because I talked to, last week alone, maybe 10 people, 2 a day that were calling in, for consults with us. And they're terrified. They just literally found out about this weeks ago from a friend, or they saw something online and didn't know they had to file these, but think the IRS is going to take all their money, put them in jail. I mean, the amount of fear was so upsetting to see.
It's insane. And then the amount of fear, this is something that we've been coming into it's something that's happened too much. The IRS has people so freaked out about this, and they go to the IRS.gov, and they're like in a rush, like, I got to do something. I don't even have time to talk to an attorney. I got to do something. Oh my God, I'm going to get arrested. And what they do is they file a streamlined submission and an OVDP submission at the same time. They don't know. No, it's just one or the other.
Oh.
They're panicking because they're like, am I going to lose my shirt? I'm going to go to jail. They're panicking. They're throwing in two out there. And the fact is, most of these people are not willful, and their streamline is the correct way to go.
Right.
But once you file that OVDP, it kills your streamline.
Oh, that
So now you're
sucks.
stuck with 8 years and doing everything. Doesn't matter how willful you are. Now you're stuck with that 27.5% penalty.
Yep.
Or you can opt out. So many people are petrified of the opt-out process. We have pretty good success with it. We've encountered some really bizarre things that are happening, and some, the things we have some things in appeal. And this is a great case for us. For a few of our appeals case, we'll just sort of casually mention this one. So really, if things are in your own name, this is really, really good news. If things are in a shell company, I don't think it's bad news. I think it still helps you a little bit here. You would say, well, what's the additional? Okay, fine. I have a shell company. What's your other fact besides a shell company? Because that on its own, it's really, so what? That's what everyone else is doing.
Right. So basically, it's less of someone trying to prove that they're innocent and more the IRS has to prove that you're guilty.
There you go. That's exactly it. And that is the standard that this is the standard the IRS has to do. And so many of the courts weren't getting it right. If they were mentioning the standard, they sure weren't acting that way.
Yep.
They were still going like, well, what did the IRS prove? Okay, I understand the taxpayer didn't file that. Right.
Yep.
No one's disputing that. But here's like, what are the things that doing? So what are the things that will? So what are the things that will lend to that? Okay. What the taxpayer says, okay, that's one. When you say, oh, yeah, I knew about it, but I couldn't be bothered.
That's bad.
That's bad. Don't say that. And then the other things, you have to get third-party evidence, an evidence of a CPA saying, I told the taxpayer all about it. He just didn't want to do it. And then the third one is where, say, a banker. A banker is going to testify against you, probably to save his own skin.
Yeah.
Oh, yeah, I told him all about it. This is part of the scheme. Yeah, he does totally want to do it. That's really what they need to find.
And even with the CPA, correct me if I'm wrong, let's say CPA mentions in passing, I think there's this thing called the FBAR. You don't really understand. You sort of check it out, but you don't think it applies to you. That's not necessarily making you willful.
No, not
you were
at all.
confused. You completely didn't understand.
Not at all. The IRS has admitted, even on Schedule B, the IRS has admitted Schedule B, Part 3, Line 7, checking no on foreign accounts does not mean you're willful. Because just like everybody else, it's a tax form. You didn't read it.
Right.
Did you read all the instructions? Did you read all the instructions and the instructions for all the forms and attachments? No, nobody does. Nobody at the IRS does. So that's something where they're like, well, right, it's sort of an adhesion contract. We're not going to claim that the failure to file this is. And then sometimes you'll have a CPA send out a tax organizer. Do you have any foreign accounts or anything like that? And the person will say no. And then you look at the questions like, well, it actually didn't ask that. It asked it in a very convoluted way and a very misleading way.
Yep.
In an order that didn't make sense, where it makes a lot of sense due to the context of this. It makes a lot of sense that the person would answer no, thinking they're answering truthfully.
Okay.
And so that's what comes up sometimes. These do happen. Everybody has bad facts. That's the thing that you didn't put this on Schedule B. A lot of people think, oh my God, that's the end of the world. I'm stuck.
Yes.
I got to pay this massive penalty. Not only that, I can't even go streamlined. No, you can go streamlined. You can go streamlined. You can opt out. These are things you can do even if you have done that. What we want to know is what was going on. And also what we want to know, is there someone who's willing to testify against you? Bad facts.
Yep.
That's something we need to know to try to decide which way we're going to go.
This is good news. I sort of want to send this video to every nervous person I talk to.
Yeah, there's a few people I've
Just
watch
watch
to.
this. You're going to be okay.
I know. It's like, here, this is a really good result.
Yep.
So the IRS can come back, refile. I don't think they're going to refile on their CIBC claim. I think that's pretty much or they're going to have to come up with some allegations they didn't come up with. The other thing too I love is the IRS swung for the fences on this one. They didn't want those non-willful penalties. No. We need to get these willful penalties. Well, in the process of doing that, they don't get non-willful penalties now. And the reason why is they only had a limited time to assess the non-willful penalties. And that time has expired. So it's not, and you can't do both. You can't do, we're going to set you a non-willful penalty and a willful penalty. It's one or the other. So if they just went for the non-willful penalties, they would have had $30,000. And the thing is, it probably would have been paid. It would be gone. But no. We want to make an example of this man. And now he's made an example of you.
I want to sit and have a beer with Jeffrey Pomerantz tonight.
Right on.
So what we'll do is we'll keep an eye on this case.
Yeah.
So if anything is refiled, if anything new happens, we will update this. So what you want to do is subscribe to our channel. That way you'll get notifications about this case and any other FBAR and OVDP information. You can like and comment below. And we also want to thank you for watching.